One of the cool things about economics is that it has a big impact on how our society works. As we've seen, ideas from economics affect the price of your Uber ride, your school books, and your medications. As we've studied monopolies, we've also seen how governments respond to situations where there's less than perfect competition. We focused on how a government can intervene in a specific market, for example, regulating the profit a monopoly can make, or by setting the efficient quantity. But there's a more global way that governments in the United States and around the world intervene to promote competition, and it's an area of law called antitrust. Questions about antitrust pop up on the AP exam occasionally, because antitrust law is an area driven by the economic models we learn in this course. Antitrust law was developed in the late 1800s. Big industries like the oil and railroad industries came to be dominated by a few huge firms. It was a classic oligopoly. These firms tried to enter agreements to limit competition, just as we've discussed in the past few lectures. But the agreements usually failed, as we would expect. Each firm had an incentive to cheat, and the agreements the firms entered weren't legally enforceable. So in the 1880s, lawyers for the Standard Oil Company, the most important oil company in the US at the time, came up with a solution. All the oil companies would basically turn over control of their company to a unified board called a trust. This board would have legal ownership of each company, so it could set adequate quantities for each firm. It was a legal way to create a cartel. And as we've discussed, forming a cartel is good for producers because it turns an oligopoly into a monopoly, raising profits. These trusts provoked huge public backlash. They allowed railroad companies, for instance, to set higher prices than they could otherwise, which understandably upset consumers. As a result, the US developed antitrust law. There are three major statutes in this area: the Sherman Antitrust Act of 1890, the Clayton Act, and the Federal Trade Commission Act. These last two came about in 1914. What all these acts essentially do is make it illegal for firms to engage in what's called anti-competitive practices. So it became illegal to form these trusts, hence the term antitrust. Firms couldn't collude on prices or lure consumers with false advertising. What does this look like in practice? There are two especially famous antitrust cases that affect things that a lot of you encounter in your lives: Hollywood movies and the National Football League. The Hollywood movie industry is a classic oligopoly. There are a handful of major studios that make nearly all the films you've seen, places like MGM, 21st Century Fox, or Warner. This has been true for almost 100 years now. A handful of major studios produce films, which they sell to movie theaters. The movie theater then has the right to show the films and charge you for the tickets. Back in the 1930s and 1940s, these powerful companies started expanding their market power. They started buying up the movie theaters. By 1945, film studios owned 1 out of every 5 movie theaters in the country. Then, instead of a free market where the studios would sell films and movie theaters would buy them, suddenly the market got a lot less competitive. MGM would buy a movie theater, then forbid the theater from showing non-MGM films, or force it to buy and show only MGM films. The US government said this would violate antitrust laws because it decreased competition. The government brought and won a case in front of the Supreme Court, and the practice ended. The movie business got more competitive. Antitrust became important for professional football, too. The NFL is the dominant football league in the US. It's composed of 32 teams. But if you think about it, each team is its own business. The New York Giants are a firm that produces football as entertainment and make money by selling tickets or TV broadcast rights or memorabilia. But as with an oligopoly, the New York Giants have a huge incentive to collude with other teams. If the Giants try to sell the right to broadcast their games for $2 billion, then the rival New York Jets could offer to sell broadcast rights for $1 billion instead. They'd have to compete to get on TV. That's the way competition works. But what if the Giants and Jets and all the NFL teams work together and say they'll only sell rights as a whole for the entire league? Then they're a monopoly and can charge higher prices. Indeed, that's what they did. In 1957, the Supreme Court ruled that this practice violated antitrust laws. But NFL teams still band together to negotiate TV deals. Between 2014 and 2022, the NFL will make $40 billion from deals with TV networks. Doesn't this violate antitrust law? The answer is, not anymore. Why? because Congress stepped in. The NFL is so popular that in response to the Supreme Court decision, Congress passed a new law saying that antitrust laws don't apply to the NFL. I guess Americans like football more than they like free markets.